What's going on, guys? It's your girl Angie Snatch coming at you with another episode of An Unbiased Truth. And today we're going to be talking about the Grandmaster Jay case. I haven't gotten a new mic yet. I'm going to get it tonight, I promise. Grandmaster Jay, aka John Fitzgerald Johnson, news broke that he would be arraigned tomorrow, that's October 25th at 9 a.m. in Louisville, Kentucky, on 5 counts of wanton endangerment in the first degree. Before I get into this, I want to say, fun fact, his name is John Fitzgerald Johnson, and he was born 9 days out after the JFK assassination, John Fitzgerald Kennedy. There's always a story in our name, and I found that very interesting that him being born 9 days after the JFK assassination, that his mother named him John Fitzgerald Johnson. Now, what if I told you that the FBI has their fingers all up and through this case? There are 2 cases that Grandmaster Jay is facing. One is this case in which he will be arraigned on tomorrow. So I'll do a follow-up video because I think we should get that information first before we get into that case. But there's another case that stemmed from the same incident. So the incident occurred in September 2020, September 4th, I believe, 2020 in Jefferson County during the Breonna Taylor protest. The NFAC, who Grandmaster Jay is the supreme leader of, they were out marching in the streets. Now, John Fitzgerald Johnson, Grandmaster Jay, had been having meetings back and forth with local police officers, so they did know that he and the NFAC would be present at the march and that they would be carrying and armed at the march. However, they gave him the advisement to keep the weapons in what is considered low ready or slung. That did not happen, and that is where these charges are stemming from. And I believe even the 5 counts that he will be facing tomorrow stem from this September 4th incident that we're about to get into, because in that original complaint, they discuss 5 officers, and he happens to have 5 charges of wanton endangerment. Now, let me get into why I say the FBI has their hands all up and through this. So this is the criminal complaint for the other case that he is facing, the case that they initially filed December 2nd, 2020. The criminal complaint was filed December 2nd, 2020 from the incidents of September 4th, 2020. Now, if you look at this page, do you see under complainant's signature? And it also puts his title. The complainant is Daniel Nally, Special Agent, FBI. So not the local police department, not the local police district. The FBI is the original complainant. Now let's get into count 1. Count 1, it says on or about September 4th, 2020 in the Western District of Kentucky, Jefferson County, John F. Johnson, aka Grandmaster Jay, the defendant, forcibly assaulted, resisted, opposed, impeded, intimidated, and interfered with any person designated as an officer and employee of the United States or any agency in any branch of the United States government. In Title 18, United States Code, Section 1114. While engaged in and on account of the performance of official duties, and used a deadly and dangerous weapon in the commission, to wit, John F. Johnson, aka Grandmaster Jay, resisted, opposed, impeded, intimidated, and interfered with the task force officer of the FBI by pointing an AR-style rifle at the officer, all in violation of Title 18, United States Code, Section 111B and 1114. Now, let's get to the second count, because this is a 2-count indictment. Remember, separate from the wanton danger one. Count 2, brandishing a firearm in relation to a crime of violence. Kentucky, on on or about September 4th, 2020, in the Western District of Kentucky, Jefferson County, Kentucky, John F. Johnson, aka Grandmaster Jay, the defendant, did knowingly brandish, carry, and use a firearm that is an AR-15 during and in relation to a crime of violence for which he may be prosecuted in a court of the United States, that is, violation of Title 18 United States Code Section 111 in count 1 above. This is why I say it's tied in, because it's saying brandishing in violation of the crime. What is the crime that they're saying? Wanton endangerment. Now let's move on to the introduction, because I found the introduction page very interesting. Let me pull it up to give a little backstory on what they're saying happened. In approximately May of 2020. So remember, we're getting this now, but they're starting it all the way back from May of 2020. An anonymous tipster from the public advised that the leader of NFAC, let me pull it up on my phone because it's a little hard for me to read it on my computer. Okay. Advised that the leader of NFAC had called for attacking Minneapolis law enforcement. The leader appealed to anyone with a firearm to join him. The tipster provided links to the videos where Johnson made the statements on YouTube. Be careful about the statements you make on YouTube. The FBI identified this leader as John F. Johnson. The FBI reviewed these videos, determining that on or about May 26, 2020, Johnson posted the two videos as his response to the city of Minneapolis regarding the death of George Floyd. At various points in the videos, Johnson makes direct threats to law enforcement along with other threats of violence. For instance, in regards to NFAC members working with the other side, no, believed to be a reference to working with law enforcement. Johnson states that if you join NFAC and we find out you're working for the other side, we will kill you. In regards to following the law, Johnson states that they, believe to be referencing NFAC, will react in any way they choose, and they don't care about the law because it doesn't benefit them. In regards to interactions with law enforcement officers, Johnson instructs his followers to assault police officers and then remove the officers' body cameras to conceal footage of them assaulting the officers. On or about May 27, 2020, Johnson, using monikers on YouTube of the official Grandmaster Jay and the Grandmaster Jay, called for incitement of violence. Pull up the next page. Call for incitement of violence against the Minneapolis Police Department. In the video, Johnson called for people to go to Minneapolis with weapons in order to hold the two officers responsible for the killing of George Floyd. Further, on June 5th, 2020, Johnson, using YouTube moniker, I'll say it again, be careful what you say on the internet. The official Grandmaster Jay stated that the only way to stop police violence is to identify and locate the homes of police, burn the houses to the ground, kill the officer, their family members, and associates. Now we're going to move on to what they consider probable cause. But before I get into the probable cause, Grandmaster Jay has a public defender in this particular case. But that public defender, he's spot on. He's on the money from me going through the case. He's on the money, because one thing about prosecution, they'll sneak things in there if they can sneak it in there. So not everything the prosecution puts in there, it's not that it's a lie, it's whether it's admissible, right? Okay, so probable cause. On the evening of September 4th, 2020, Officers from the Louisville Metro Police Department were conducting overwatch and surveillance of a crowd that had gathered in Jefferson Square Park. Various protest groups had chosen this park, likely due to its close approximation, why didn't they put proximity? To various local governmental buildings, to congregate related to ongoing national protests / civil unrest and related to the Breonna Taylor investigation. Officers were located inside and on the roof of the Jefferson County Grand Jury building located at 514 West Liberty Street, Louisville, Kentucky. At a time prior to 8:34 p.m., a Louisville Metro Police Department radio transmission occurred advising officers that 6 to 8 heavily armed individuals were parked on Armory Place next to the parking garage structure. Federally deputized task force officers referred to as, now this is where I said that the wanton endangerment charges that he's facing tomorrow are going to come in, referred to as TFO number 1 and TFO number 2, and LMPD officers, that's Louisville Metro Police Department officers, referred to as officer number 1, officer number 2, and officer number 3. If you keep in count with me, that is 5 officers. Went to the roof of the Jefferson County Grand Jury building to take up an overwatch position on the eastern edge looking down on Armory Place. The purpose was to observe the unknown armed individuals on Armory Place and try to determine their intentions. Upon arriving at the eastern edge of the roof, and I'm sorry because this is a little under the water mark, the officers and TFOs began their surveillance. A short time after initiating surveillance, TFO number 1, officer number 1, let me pull up the next page, officer number 1 and officer number 3 were blinded by a light which shortly thereafter determined was a flashlight mounted to the rifle being aimed at them by Johnson. Officer number 2 advised he was not blinded by the flashlight because as soon as he saw Johnson begin to raise his rifle, he pulled himself back away from the roof edge to take cover. TFO number 2 advised he was not blinded by the flashlight, but also pulled himself back away from the roof edge after hearing TFO number 1 announce that Johnson had aimed his rifle at the officers and TFOs on the roof. The FBI interviewed all the officers and TFOs above. They all advised that they identified the individual on Armory Place who aimed the rifle at them as being Johnson. They knew him by his AKA Grandmaster Jay and the group as being NFAC members. Johnson and the NFAC members had been observed by TFO number 2 and officer number 2 earlier in the day at G.G. Moore Park and were driving the same vehicles and dressed in the same clothing. Additionally, all the officers and TFOs were familiar with Johnson's appearance, mannerisms, and tactics due to NFAC's march in Louisville on July 25th. 2020. Remember, I said this goes back to May. They've been having conversations with him on if they were going to come, how they would need to behave. July 25th, 2020. And from them watching various online and social media videos posted by Johnson, the officers and TFOs advised they all perceived a threat from Johnson based on him aiming his rifle at them. All officers advised they were concerned Johnson might intentionally or even accidentally discharge a round at him. All officers recognized that the distance between themselves and Johnson was well within the effective range of an AR platform-style rifle. TFO number 2 and officer number 3, who were wearing soft body armor, were aware that soft body armor would not stop a rifle round. The officers and TFOs advised that approximately 30 seconds after Johnson aimed his rifle at them, Jesse Holiday, special advisor to the Louisville Metro Police, she is one of the people that testified. Now, I want to go into this background. This is the part where I said, so what we saw on October, let me stop for a second. What we saw on October the 20th was actually them having a Lamine motion hearing. So what the Lamine motion hearing, what a Lamine motion is they're having a hearing in the background before a jury is selected to determine what testimony, what background is admissible. And that's why I said that this defense attorney that he has is very good, because with this background that they put out on Johnson, now he has of pulling that gun out and not playing games with people. However, they cannot charge him if he got off on these things, and that doesn't mean that it is admissible just because these things happen. It doesn't mean that it's admissible in this case, because in this case what they're saying is that he brandished a weapon. He did not discharge a weapon or anything like that. It was just perceived as threatening to officers. That's why they're giving that wanton endangerment, right? Like you were so careless that you put people in danger. Possibly. So let's go into the background. This is the background. Before I read it, this is the background that the defense attorney filed the Lamine motion for to get suppressed. This is his history of violence. The FBI, told you they all up in here. The FBI conducted a review of Johnson's criminal history, which showed a pattern of Johnson making threatening statements and then using a rifle or long gun to further threaten various individuals, including women and his wife. On or around March 10th, 1995, Johnson was arrested for intentionally and knowingly caused bodily injury to Raisha Williams by striking her on the left side of her face several times with a closed fist, causing pain. Johnson was also arrested for intentionally and knowingly using a deadly weapon, to wit, Westerfield 20-gauge shotgun, manifestly designed, made, and adapted for the purpose of inflicting death and serious bodily injury, and did then and there threaten Jose Antonio Reyes with imminent bodily injury by the use of said deadly weapon. The same charge was applied to 3 other victims. The FBI arrested Johnson upon criminal complaint on August 4, 2003. Now, this is gangster for real. Like, this is gangster to me for him to even be bold enough. So, on August 4, 2003, based on Johnson's actions at the Fort Bragg military reservation, he went on to Fort Bragg, on August 1st, 2003, according to the affidavit filed by the FBI agent, Johnson threatened to kill his wife, Shanice Johnson, and her platoon sergeant. This is on the base. And he had a gun. While Shanice's unit was having a formation and recognition ceremony on Fort Bragg. According to the affidavit, Shanice's unit had just returned from overseas duty in Kuwait on July 30th, 2003. Shanice had been having marital problems with Johnson and claimed to be a victim of mental and physical abuse in the marriage. Let me give you just a little bit of background on that. So that platoon sergeant, she was having an extramarital affair. She was dating him. On August 1st, 2003, Johnson told Shanice he was going to kill your friend. After this statement, let me go to the next page. After this statement, Johnson reached for a rifle in the trunk of his vehicle, and Shanice tried to stop him, but Johnson threatened to kill Shanice if she didn't get away. Now, remember, he is a military veteran himself, and even after this incident, he rejoined as a reservist in the military. The FBI obtained Johnson's United States military record, which revealed he was a single chapter radio operator in Virginia National Guard from April 27, 1989 until October 16, 1990. According to Johnson's DD-214, Certificate of Release or Discharge from Active Duty, he served active duty in the United States Army from July 1998 until September 1999, after which time he was discharged under other than honorable conditions and demoted to the rank of private. So he was not dishonorably discharged. I never heard of other than honorable, but I'm not in the military, so maybe that's something. But he was demoted to private. Further review indicates Johnson accepted this discharge in lieu of trial by court-martial. So that's what they basically, he cut a deal with the Army-Navy court. On March 18, 2005, Johnson was placed on AWOL status for lying about an appointment and being assigned to quarters. On March 21st, Johnson was classified as a deserter, absentee. On March 1st, 2006, Johnson was apprehended and returned to U.S. military custody, where he was charged with being AWOL from March 2005 until March 2006. On March 9, 2006, Johnson requested discharge in lieu of trial by court-martial, and this request was approved. Johnson was discharged for a second time. Jesus, they just kept letting him back in. Under other than honorable discharges. On March 24, 2006, Johnson was reduced in rank from sergeant to private. The FBI is continuing to investigate how Johnson re-enlisted in the U.S. military after being discharged previously under other than honorable conditions. Yeah, they should get to the bottom of that. I think part of it has to do with that ex-wife of his and those extramarital affairs, because, you know, those are charges that she and her platoon sergeant could have been facing as well. So they could have said, look, man, you just leave. Don't make any fuss about it. We won't make any fuss about it, and kept it under wraps. Now, I want to show you the evidence that they have listed. So these two pictures are listed in the evidence in this case. They supposedly or purportedly show him pointing in the air at the officers that are on the roof, as well as they're saying that he was pointing at a helicopter that was flying overhead. Here's another picture that they put in there. Now, the FBI, I said, is all over this. There is a portion of the evidence that is sealed, and then there's another portion of the evidence that is redacted. So though this is available to us in the public, it is heavily redacted. You can barely read what they're talking about. They're talking about that they will be providing the videos for this case to Jefferson County prosecution, that they will be providing statements, that they have recordings. Basically, he's been on the FBI watch list, and NFAC has been on the FBI watch list for quite some time. Lamine motion, that's what happened October 20th. So the Lamine motion that happened on October 20th was, let me pull it up. It was brought up by his attorney, public defender, to suppress evidence. Basically, what they're trying to suppress is that incident with his wife and the incident with him pulling out the gun and hitting the woman. I think that is fair game, and they ended up getting that. Motion granted. This is his public defender. His public defender is Donald Meyer. They ended up getting that motion granted because what they showed was that specific case in Texas, it was dismissed. And not dismissed with prejudice. This is the form, the motion to dismiss, filed by the prosecution in El Paso, Texas. And if you see, it says the evidence is insufficient. So they cannot use that as a point of background to show that this person has had the intentions of attacking people previously if this was dismissed because they didn't have evidence. That means that there was no evidence saying that that happened. Well, no evidence that they could prosecute anyway. This is the order granted. So it was granted in part. So the things that the judge let in were certain photographs and videos that the FBI will be turning over to Jefferson County. They will be letting in. However, they will not be letting in those previous incidents. And I think that's a win, especially having a public defender. Especially having a public defender for him to catch that, no, this shouldn't be admissible, because we know what public defenders do, okay? No offense, but we know what public defenders do. And I think it says a lot that this public defender caught that these things had been dismissed, and one for insufficient evidence, and the other with the Fort Bragg base had been in lieu of going to court and being court-martialed, that they gave him a demotion and that he re-enlisted. So it's going to be really hard for them to use this evidence. Actually, not hard at all. They can't. They just can't at all. But on tomorrow, when he goes before the court in Kentucky on these 5 wanton endangerment charges, I think this story will come all full circle, because what they're doing is they're going to charge him in the federal side and they're going to charge him on the state side. I'm interested to see what will happen. Now, for this case that I just broke down to you with the 2 counts, the judge is giving them, both parties, until November the 10th. They have until November the 10th to come back to the judge with a schedule that they both can agree on. Now, if you're wondering why it took so long from a case December 2nd, what they were doing was the state was using, and the federal government, they were using COVID to their advantage. They were basically saying the courts are so jam-packed, we need more time. Grandmaster Jay, he was filing for dismissal because they took so long to indict him. They had 30 days usually to indict him and his right to speedy trial, but they keep resetting that speedy trial clock. So even right now, the judge has paused the speedy trial clock until November 10th. Then from November 10th, that's when the speedy trial will apply. Let me know what you guys think. The FBI is coming hard at this man, and we shall see the outcome. All right, guys, it's Angie Snatch. Be careful out here in these YouTube streets, honey. It is dangerous. Do not air your business on YouTube or any social media platform. You will not hear from Grandmaster Jay because the judge, since December the 4th, he has been prohibited from posting anything to social media at all. He cannot post to social media, and he can only travel between Ohio and Kentucky, and that's for court only. The October 20th hearing that they had, that was done by telephone, so he wasn't arrested on that. He's already on probation. They already have an officer that he has to report to since last year. So we'll see tomorrow. All right, guys, it's Angie Snatch.